A longtime assistant to Ohio Judge Leslie Celebrezzi has sued the judge, alleging that the judge retaliated against her after the assistant provided access to public court documents to a reporter. The reporter then went on to pen several articles alleging that the judge had steered many lucrative receivership cases to her alleged lover. Those receivership cases are to the tune of about $500,000 in benefits to the receiver and his family. Let's have a look. According to the Cleveland News, Judge Leslie Celebrezzi steered cases to lover. FBI interviewed demoted assistant over judge's conduct. The assistant claims the judge retaliated against her after legally and dutifully providing public records to a reporter. This article is penned by Phil Trexler of the Marshall Project. That's going to become important later on because the Marshall Project is cited frequently in the complaint. A former assistant to Cuyahoga County Domestic Relations Judge Leslie Ann Celebrezzi claims in a lawsuit that she was demoted because she knew of the judge's scheme of steering lucrative receivership cases to her lover. The lawsuit, filed this week by court employee Georgiana Samari, also alleges agents with the FBI Cleveland-based Public Corruption Unit have questioned her regarding the judge's conduct. The FBI requested the interview after the Marshall Project of Cleveland reported her demotion on August 22nd. Ms. Samari is a witness who knows facts about criminal acts, the lawsuit claims. Samari's lawsuit alleges the judge retaliated against her, leading up to her $20,000 pay cut after Samari provided public court records to a Marshall Project reporter investigating the judge's relationship with court-appointed receiver Mark DeTore. Samari was hired by Celebrezzi in 2008 when the judge first won election, and their friendship evolved over the years. The judge confided in Samari her affection for DeTore, whom Celebrezzi has known most of her life, the suit alleges. The Marshall Project has previously reported DeTore has been paid about $500,000 in fees from divorcing couples in Celebrezzi's court. So just to give you a lay of the land here, this is a family law judge. And oftentimes in family law cases, either one spouse or the other or both own a business. And the spouse who owns the business has the ability to either A, scuttle the business during the divorce proceedings to avoid paying the other spouse from the assets in the business, or to hide money in the business to avoid paying the spouse personal assets. Receivers are sometimes appointed to ensure that neither of these two things occur. So essentially what the article is saying is that Judge Celebrezzi was appointing a specific receiver to lucrative cases within the court based on her relationship with that receiver. And $500,000 in receivership fees is, as you can imagine, quite a bit of money. So let's have a look at the complaint. We're going to just get right into the facts here. Ms. Samari met defendant Celebrezzi in about 2007 while Celebrezzi was still a magistrate at Cleveland Municipal Court, and Ms. Samari worked in central scheduling. Ms. Samari worked on Celebrezzi's campaign for the DR Court. After Celebrezzi won election in 2008, the judge asked Ms. Samari to be her judicial assistant. Over the years, defendant Celebrezzi and Ms. Samari formed a close personal bond, and she gives several examples. In Ms. Samari's most recent November 2022 performance evaluation, which Celebrezzi personally signed, Celebrezzi rated Ms. Samari with the highest rating as exceeding expectations on all 5 criteria: quality of work, initiative, communication and teamwork, decision-making and problem-solving, and public service skills. This was a perfect score. On the On top of regular salary increases that would boost her lifetime pension based on the highest 3 years of compensation, Miss Samari even received bonuses for exceptional performance. Miss Samari had never received even oral counseling or a reprimand in her entire career with the DR court. She had a flawless record as a public servant. Defendant Celebrezzi regularly appointed Mark Dauteur or his daughter as the receiver of parties' assets and finances on the cases on her docket, resulting in lucrative fees to them. As a close friend of Judge Celebrezzi's for over 15 years, and as Celebrezzi well knew, Miss Samari knew about and was witness to the years-long affair between Celebrezzi and Mark Dauteur, and she gives examples of that. On April 28, 2023, Marshall Project reporter Mark Puente visited the court clerk's office and reviewed many closed Celebrezzi case files for records about her appointments of Dauteur and his daughter as receivers. The court's clerks, whom Celebrezzi did not know to have first-hand knowledge of her affair with Dauteur, handed those files to Mr. Puente without inspecting them beforehand. Unlike Miss Samari, who knew about the affair, the clerks faced no consequence for making open court records available. What Mr. Puente was seeking about Dauteur was in an active case file and thus in Celebrezzi's chambers. The clerks directed Mr. Puente upstairs to her chambers. So Mr. Puente went to then Judicial Assistant Miss Samari's office. Miss Samari, on the DR Court's behalf, was required by the First Amendment and Supreme Court of Ohio's Rules of Superintendents 44 through 47 to permit access to public court records stored in Judge Celebrezzi's office. Under Rule of Superintendents 45A, court records are presumed open to public access. And under Rule 45B1, a court or clerk of court shall make a court record available by direct access, promptly acknowledge any person's request for direct access, and respond to the request within a reasonable amount of time. And there would have been nothing reasonable about delaying direct access to a single court file in response to Mr. Puente's request for direct access. Mr. Puente provided Miss Samari with the name and number of the case he wished to review. It was not an abuse, neglect, or dependency case. She's saying that because in abuse, neglect, and dependency cases, you have to redact certain information. She's basically alleging there was no redaction required here. She pulled the relevant file and examined it to ensure the judge's personal notes were not in it and that nothing was marked as being under seal or confidential. Ms. Samari's review was standard protocol when someone requested a case to review. She handed only open court records to Mr. Puente. Again, Celebrezzi never objected to this practice or directed Miss Samari otherwise. When, in a matter of minutes, Mr. Puente had found what he was looking for, which was court filings related to Dauteur, he asked Miss Samari to make a copy of them, which she did, just as she would have done for anyone else. She knew he hadn't taken anything from that file, and she knew that these were copies of court papers listed on the docket. She copied nothing confidential for him. Within minutes of her text to Celebrezzi, so immediately after this happens, she realizes that this is a reporter. And so then she becomes suspicious. She kind of feels like perhaps the judge is not going to be happy about what just happened. So she texts Judge Celebrezzi. Within minutes of her text to Celebrezzi, court administrator defendant James Zack called and interrogated Miss Samari. Zack specifically demanded to know why Miss Samari allowed Mr. Puente to review the files. Zack also asked several questions about what Mr. Puente had done with the files, whether he took pictures, and where he reviewed the files. Miss Samari answered his questions, specifically telling Zack that Mr. Puente had asked for copies of the Dauteur-related court filings. On May 1st, 2023, Ms. Samari received an email from Defendant Sweeney scheduling a meeting among Defendant Sweeney, Ms. Samari, and Defendant Zack for May 3rd, 2023. At 1:30 p.m. on May 3rd, 2023, Ms. Samari met with defendants Sweeney and Zach. Zach asked Ms. Samari to explain what happened when Mr. Puente came to her office. Ms. Samari explained the day's events. She reiterated that the records were public and that for 15 years she had shared them with those who came to the judge's office and asked. Defendant Zach gave Ms. Samari a written counseling for providing public court records to a reporter. In so doing, Zach, complicit with the other defendants, created a false written document for Ms. Samari's personnel file alleging that she had shared confidential information when, as defendants well knew, she had not done so, and he had no evidence that she had. The document, with the official seal of the Cuyahoga County Court of Common Pleas Domestic Relations Division on it, was entitled Written Counseling. Under Description of Violation, it read, on Friday, April 28, 2023, Georgiana Samari gave a court file containing confidential information to Mr. Mark Puente without first notifying and receiving permission from either Judge Leslie Ann Celebrezzi or Court Administrator Jim Zach. Without authority or permission to do so, Ms. Samari allowed Mr. Puente to remove the file from the court office and review its contents without supervision. Ms. Samari's actions violated Employee Handbook sections 2.10 and 2.11 and the Code of Ethics as outlined below. So essentially, they're saying that she gave confidential information to Mark Puente. But the plaintiff here is alleging that for 15 years, the protocol was in place. She followed the protocol, and not only her, but all of the court employees followed the protocol, which was to immediately give access to court records to people who come to the court requesting them, because that's what the Constitution says to do. But we're going to see that the court here is saying, well, no, there was an additional thing that you were supposed to do, even though you haven't done it for the last 15 years. Although the document claimed Ms. Samari had shared confidential information with Mr. Puente, it conspicuously failed to identify anything confidential in the file Ms. Samari had made available to Mr. Puente, much less explain how defendants had arrived at such a bogus conclusion. Relieved that she wasn't being fired and prepared to take her lumps for angering Celebrezzi, Ms. Samari did not ask. The statement that Ms. Samari's actions violated Employee Handbook sections 2.10 and 2.11 and the Code of Ethics was also false, as explained next. The Court Employee Handbook section 2.10 states, an employee must not exhibit or divulge the contents of any record to any person, including other employees, except in the conduct of the employee's work assignments and in accordance with court policy and the Ohio Rules of Superintendents. An employee must not remove or cause to be removed copies of any record or report from any file from the office where it is kept, except in the performance of the employee's duties. Ms. Samari was conducting her work assignments in accordance with court policy and the Ohio Rules of Superintendents. She was performing her duties. The written counseling Ms. Samari received also quoted in Employee Handbook section 2.11, which states, the production or release of any court records or documents resulting from a public records request, including media requests, is governed by Rules 44 through 47 of the Ohio Rules of Superintendents for the Courts of Ohio. A request for production or inspection of any court records or documents must be promptly presented to court administration. Any communication or follow-up regarding the request will be handled by court administration. In Ms. Samari's 15 years of experience working with Judge Celebrezzi, the second and third sentences of this section were not followed or enforced. Celebrezzi, like the other judges, had authorized and indeed directed in-chambers personnel like Ms. Samari to make active case files open and available to the public consistent with Rules 44 through 7 of the Rules of Superintendents, generally providing direct access to court records, and knew that personnel had regularly done so. To the best of her knowledge, any purported requirement that every request from every law firm, runner, lawyer, journalist, or member of the public be routed to court administration was simply not followed. Staff had not been trained on such policy, and as a practical matter, it was unworkable for every staff member of every DR court chambers to route through central administration anyone who showed up seeking open case files. Only when the request was from someone whom Miss Mary, at the end of the interaction, learned happened to be a journalist and one who was investigating Celebrezzi's illicit, amorous, and business relationship with Dottor did court officials contrive such discipline to retaliate against and intimidate Miss Mary. Defendants' excuses for punishing Miss Mary were pretexts for retaliation and witness intimidation. And even if Miss Mary had violated some written policy that would not have justified her friend and boss, the administrative judge of the DR court, ostracizing her and never speaking with her again. Celebrezzi's burning fury was fueled by retaliatory animus and intimidatory intent. After the meeting, defendant Sweeney, complicit with the other defendants, also created a false written document, her purported notes. The notes claimed, among other false statements, that Miss Mary had said, "Not sure if anything taken," and "Not sure if any confidential information." In truth and in fact, Miss Mary had clearly and unambiguously told defendant Sweeney and the others in the meeting that Mr. Puente had taken nothing other than the copy she made for him, and that Miss Mary had personally inspected the file to ensure it contained no confidential information. On May 26, 2023, 23 days after the written counseling meeting, defendant Seaton, the deputy court administrator, summoned Miss Mary to his office. Again, Miss Mary was given no notice about the purpose. When Miss Mary went to defendant Seaton's office, defendant Ergen, the director of judicial operations, was there as well. Defendants Seaton and Ergen slid a piece of paper to her and told her she was being demoted to the position of scheduler, a position she had last held 14 years earlier with the Cleveland Municipal Court. Miss Mary was shocked because defendant Zach had assured her that a written counseling would be the full extent of the disciplinary action against her for providing public records to a journalist. Now she was being punished a second time, apparently for the same purported offense. Miss Mary pleaded to know why she was being demoted, but neither defendant Seaton nor defendant Ergen said a word. They just sat there and looked at her. She asked again. They again said nothing, continuing to stare at her in silence. Miss Mary asked whether her pay would be affected, and defendants Seaton and Ergen said they could not answer. They added that it would be up to Celebrezzi. At 5 p.m. that same day, the Marshall Project published a judge, a kiss, and $450,000 plus in court work. An investigative report about accusations that Judge Celebrezzi was in an illicit relationship with Mark Dottor, a man she often appointed receiver. The article detailed a Supreme Court of Ohio filing questioning the relationship between defendant Celebrezzi and Dottor, who had been appointed receiver in a divorce case. One of the parties in that case, Jason Jardine, filed an affidavit of disqualification trying to remove Celebrezzi from presiding over the case. Jardine hired a private investigator to investigate Celebrezzi and Dottor's relationship, according to the article. The investigators caught Celebrezzi and Dottor kissing on the lips outside of Delmonico's Steakhouse in Independence on March 22, 2023, and the Marshall Projects and Cleveland Sames magazines websites published a video of the kiss. In the video, Celebrezzi turned toward Dottor as he leaned in. She seized and cupped his face tenderly and kissed him on the lips. According to the article, Dottor claimed he met with Celebrezzi at his home on Fridays to work on court programs and special projects. There appeared to be no explanation for what sorts of so-called special projects a court-appointed receiver and supposedly independent judge who appoints him to charge against litigants' assets could or should possibly be working on. On June 5th, 2023, a few days after the Marshall Project's article published, Miss Mary received an email from defendant Zach setting yet another meeting for June 7th, 2 days later. Miss Mary emailed Zach back asking to postpone the meeting so she could have an attorney present. Rather than reply, Zach tracked down Miss Mary in a hallway and handed her an envelope. Inside was a letter informing Miss Mary that her salary was cut by almost $20,000 a year, and therefore the pension she would have otherwise received after future raises would also be cut. The letter, dated July 7th, falsely stated that she had been informed about the salary cut during the May 26, 2023 meeting with defendants Seaton and Ergen. In truth and in fact, both had remained mum on why she was being demoted, and neither had been able to tell her if her salary would be cut, saying that it was up to defendant Celebrezzi. Defendants deliberated back and forth over the content of this document, and Defendant Seaton specifically emailed Defendant Zach on June 6 that he and Urgent had not stated that Miss Mary would receive a salary reduction. But Zach, on defendant's behalf, proceeded to make the false statement anyway. Since her demotion and pay cut, Miss Mary continued to be persona non grata at the DR court. People she considered friends no longer spoke to her and did not call to ask her how she's been since the retaliation and intimidation started when she was demoted, with her pay slashed. Some people who would talk to her would suddenly stop if they saw Celebrezzi nearby. They would say they couldn't have Celebrezzi see them talking to her. The retaliation, intimidation, and defendant's conduct have been widely discussed among the DR court judges and court personnel. Other DR court judges knew that Celebrezzi was having an affair with Dottor. Celebrezzi told at least one of them that she loved Dottor. Celebrezzi never disclosed her affair with Dottor to any of the parties or attorneys before her, where she appointed or contemplated appointing Mark Dottor or his daughter as receivers. She knew that if she did, parties would object to her handing over their assets to someone with whom she was having an intimate relationship. They would be rightly concerned that she could not be objective in evaluating or approving Dottor invoices bleeding their assets. Defendants, including Celebrezzi, knew that Miss Mary had information as a witness that would publicly expose Celebrezzi's affair and relationship with Mark Dottor and cast doubt on the objectivity and propriety of all Celebrezzi's judicial acts of appointing him as a receiver and approving his and his daughter's fees and expenses. Miss Mary's witness status is confirmed by the fact that she has been interviewed about Celebrezzi by the Federal Bureau of Investigation, Cleveland-based Public Corruption Squad. So those are the facts that Miss Mary is alleging against Miss Celebrezzi and others. And based on those facts, she has laid out quite a number of counts against these people. And basically, she's thrown everything at this. Everything that you could possibly imagine, she has thrown at this. And if these allegations are correct, this is judicial misconduct layered on top of judicial misconduct. So the misconduct here is mind-boggling. If these allegations are correct, essentially, this judge shouldn't be judge anymore. Not only that, but she shouldn't be an attorney anymore, because she still has to hold to the oaths that attorneys take even after she became a judge. So there's that piece of this. The other piece of this is that Miss Sweeney has essentially lost everything that she has been working toward for the past 15 years of her life because of Miss Celebrezzi's actions. And just putting her back in her prior position isn't enough, because putting her back in her prior position just puts her back in an environment where everybody is essentially looking at her as if she has done something wrong, when, according to the allegations in this complaint, she wasn't doing anything wrong. She wasn't the person that was was not complying with the laws and judicial protocol. So essentially, it looks like perhaps the only thing that Miss Mary can get is for her pension to be reinstated at a higher rate, I guess, and to be awarded monetary or to be awarded monetary damages that would compensate her for the lack of her pension being able to be elevated. But that's just this attorney's thoughts. Let me know what you think in the comments below. For now, my name is Nathan Saunders, and this is The Legal Good.